Chapter 9, Reverter of Domicil, SS 190. The maxim domicile of origin reverts easily has already been discussed so far as it is a principle of evidence by which to decide between acquired domicile and domicile of origin. But there is in the principle of reverter also a technical and peculiarly artificial side, according to which the factum required in the ordinary change of domicile, to wit, a change of bodily presence from one place to another, is in part dispensed with. SS 191. The rule of reverter as laid down by Story. Story thus lays down the rule: if a man has acquired a new domicile, different from that of his birth, and he removes from it with an intention to resume his native domicile, the latter is reacquired even while he is on his way in itinerary, for it reverts from the moment the other is given up. This he states as the rule applicable to changes of domicile from one place to another within the same country or territorial sovereignty, that is to say, quasi-national domicile. With respect to changes between different countries or sovereignties, he lays down the following: a national character acquired in a foreign country by residence changes when the party has left the country animo non revertendi and is on his return to the country where he had his antecedent domicile, and especially if he be an itinerant to his native country with that intent, his native domicile revives while he is yet in transitu, for the native domicile easily reverts. The moment a foreign domicile is abandoned, the native domicile is reacquired, but a mere return to his native country without an intent to abandon his foreign domicile does not work any change of his domicile. The only fair construction which can be put upon these passages is that reverter takes place only when the party has abandoned his acquired domicile and is in itinerary to the place of his original domicile. And this, as we shall see, is the American doctrine. This is but reasonable and just, for it seems but right that a person who has turned his back upon his adopted country and his face toward his native country should be deemed to intend to deliver himself from the dominion of the laws of the former and subject himself to the laws of the latter, and but right, further, for courts to give effect to such intention. SS 192. The British Doctrine. Udney v. Udney. The British Doctrine, however, goes further. It has already been referred to, and can now be best stated in the language of the judges who created it. Udney v. Udney was a case involving legitimation per subsequens matrimonium. It originated in Scotland and came up from the Court of Session to the House of Lords on appeal. The facts were as follows. Colonel Udney, though born at Leghorn in 1779, where his father was consul, had by paternity his domicile in Scotland. He does not appear to have acquired any new domicile up to 1812, when he was married and took upon lease a house in London, where he resided for 32 years, paying occasional visits to Scotland. In 1844, having got into pecuniary difficulties, he broke up his establishment in London and repaired to Boulogne, where he remained for 9 years, occasionally visiting Scotland as before. In 1846 his wife died. Some time after the death of his wife he formed an illicit connection at Boulogne with Miss A, which resulted in the birth in England of a son in 1853. Miss A having come to England, and Udney having accompanied her for the purpose of procuring the attendance of an English accoucheur. The parents of this child, who was the respondent in this case, were subsequently, in 1854, married in Scotland, and the question was whether respondent, under these circumstances, had become legitimate per subsequens matrimonium. The Court of Session decided that Colonel Udney's domicile of origin was Scotch, and that he had never subsequently lost it, notwithstanding his long absence from Scotland, and that his son, the respondent, though illegitimate at his birth, was legitimated by the subsequent marriage of his parents. The House of Lords ordered and adjudged that the interlocutor of the Court of Session be varied by substituting for the words that he never lost his said domicile of origin these words, and if such domicile of origin was ever changed, yet by leaving England in 1844 his domicile of origin reverted, and with this variation affirmed the interlocutor. It thus appears that the question of reverter was squarely before the House, and after the case had been argued by eminent counsel, the law lords delivered their opinions as follows. As the case is one of much importance, they are here given at length. SS 193. ID. Lord Hatherley S. remarks. Lord Chancellor Hatherley said, I am of opinion that the English domicile of Colonel Udney if it were ever acquired, was formally and completely abandoned in 1844, when he sold his house and broke up his English establishment with the intention not to return. And, indeed, his return to that country was barred against him by the continued threat of process by his creditors. I think that on such abandonment his domicile of origin revived. It is clear that by our law a man must have some domicile, and must have a single domicile. It is clear on the evidence that the colonel did not contemplate residing in France, and, indeed, that has scarcely been contended for by the appellant. But the appellant contends that when once a new domicile is acquired, the domicile of origin is obliterated, and cannot be reacquired more readily or by any other means than those by which the first change of the original domicile is brought about, namely, an ipso facto. He relied for this proposition on the decision in Monroe v. Douglas, where Sir John Leach certainly held that a Scotsman, having acquired an Anglo-Indian domicile, and having finally quitted India, but not yet having settled elsewhere, did not reacquire his original domicile, saying expressly, "I can find no difference in principle between an original domicile and an acquired domicile." That he acquired no new domicile may be conceded, but it appears to me that sufficient weight was not given to the effect of the domicile of origin, and that there is a very substantial difference in principle between an original and an acquired domicile. I shall not add to the many ineffectual attempts to define domicile, but the domicile of origin is a matter wholly irrespective of any animus on the part of its subject. He acquires a certain status civilis, as one of your lordships has designated it, which subjects him and his property to the municipal jurisdiction of a country which he may never even have seen, and in which he may never reside during the whole course of his life, his domicile being simply determined by that of his father. A change of that domicile can only be effected in ipso facto, that is to say, by the choice of another domicile, evidenced by residence within the territorial limits to which the jurisdiction of the new domicile extends. He, in making this change, does an act which is more nearly designated by the word settling than by any one word in our language. Thus we speak of a colonist settling in Canada or Australia, or of a Scotsman settling in England, and the word is frequently used as expressive of the act of change of domicile in the various judgments pronounced by our courts. But this settlement and ipso facto by which the new domicile is acquired is, of course, susceptible of abandonment if the intention be evidenced by facts as decisive as those which evidenced its acquirement. It is said by Sir John Leach that the change of the newly acquired domicile can only be evidenced by an actual settling elsewhere, or by the subject of the change dying in itinerary when about to settle himself elsewhere. But the dying in itinerary to a wholly new domicile would not, I apprehend, change a domicile of origin if the intended new domicile were never reached, so that at once a distinction is admitted between what is necessary to reacquire the original domicile and the acquiring of a third domicile. Indeed, the admission of Sir John Leach seems to have been founded on the actual decision of the case of Colville v. Lauder, cited in full in Monroe v. Douglas from the Dictionary of Decisions. In that case, a person of Scottish origin became domiciled at St. Vincent, but left that island, writing to his father and saying that his health was injured, and he was going to America, and that if he did not succeed in America, he would return to his native country. He was drowned in Canada, and some memoranda were found indicating an intention to return to Scotland, and it was held that his Scottish domicile had revived. It seems reasonable to say that if the choice of a new abode and actual settlement there constitute a change of the original domicile, then the exact converse of such a procedure, namely, the intention to abandon the new domicile, and an actual abandonment of it, ought to be equally effective to destroy the new domicile. That which may be acquired may surely be abandoned, and though a man cannot, for civil reasons, be left without a domicile, no such difficulty arises if it be simply held that the original domicile revives. That original domicile depended not on choice, but attached itself to its subject on his birth, and it seems to me consonant both to convenience and to the currency of the whole law of domicile, to hold that the man born with a domicile may shift and vary it as often as he pleases, indicating each change by intention and act, whether in its acquisition or abandonment, and further, to hold that every acquired domicile is capable of simple abandonment in ipso facto, the process by which it was acquired without its being necessary that a new one should be at the same time chosen. Otherwise, one is driven to the absurdity of asserting a person to be domiciled in a country which he has resolutely forsaken and cast off, simply because he may be deliberating before he settles himself elsewhere. Why should not the domicile of origin, cast on him by no choice of his own, and changed for a time, be the state to which he naturally falls back when his first choice has been abandoned in imo et facto, and whilst he is deliberating before he makes a second choice? Lord Cottenham, in Monroe v. Monroe, says, so firmly indeed did the civil law consider the domicile of origin to adhere, that it holds that if it be actually abandoned and a domicile acquired, but that again abandoned, and no new domicile acquired in its place, the domicile of origin revives. No authority is cited by his lordship for this. He probably alluded to some observations which occur in the case of Ladd, Virginie, where Sir William Scott said, it is always to be remembered that the native character easily reverts, and that it requires fewer circumstances to constitute domicile in the case of a native subject than to impress the national character on one who is originally of another country. In the case of the Indian chief, the question was whether the ship was the property of a British subject, for if so, her trading was illegal. The owner, Mr. Johnson, averred that he was an American. Sir William Scott held him to be an American by origin, but that, having come to England in 1783 and remained till 1797, he had become an English merchant. And Sir William Scott says, the ship arrives a few weeks after his departure, and taking it to be clear that the natural character of Mr. Johnson as a British merchant was founded on residence only, that it was acquired by residence, and rested on that circumstance alone, it must be held that from the moment he turned his back on the country where he had resided on his way to his own country, he was in the act of resuming his original character, and is to be considered as an American. The character that is gained by residence ceases by residence. It is an adventitious character, which no longer adheres to him from the moment that he puts himself in motion bona fide to quit the country sign and imo revertendi. Story, in his Conflict of Laws, Sect. 47, says, if a man has acquired a new domicile different from that of his birth, and he removes from it with intention to resume his native domicile, the latter is reacquired even while he is on his way, for it reverts from the moment the other is given up. The qualification that he must abandon the new domicile with the special intent to resume that of origin is not, I think, a reasonable deduction from the rules already laid down by decision, because intent not followed by a definitive act is not sufficient. The more consistent theory is that the abandonment of the new domicile is complete in imo et facto, because the factum is the abandonment, the animus is that of never returning. I have stated my opinion more at length than I should have done were it not of great importance that some fixed common principles should guide the courts in every country on international questions. In questions of international law we should not depart from any settled decisions, nor lay down any doctrine inconsistent with them. I think some of the expressions used in former cases as to the intent, exurpatrium, or to become a Frenchman instead of an Englishman, go beyond the question of domicile. The question of naturalization and of allegiance is distinct from that of domicile. A man may continue to be an Englishman, and yet his contracts and the succession to his estate may have to be determined by the law of the country in which he has chosen to settle himself. He cannot, at present at least, put off and resume at will obligations of obedience to the government of the country of which at his birth he is a subject, but he may many times change his domicile. It appears to me, however, that each acquired domicile may be also successively abandoned simpliciter, and that thereupon the original domicile simpliciter reverts. SS 194. ID. Lord Chelmsford S. remarks. Lord Chelmsford said, my lords, at the opening of the argument of this appeal for the respondent, his learned counsel were informed that your lordships were of opinion that the domicile of Colonel Udney down to the year 1812 was his Scotch domicile of origin, and that the case was therefore narrowed down to the questions raised by the appellant, whether that domicile had been superseded by the acquisition of another domicile in England, and whether such after acquired domicile was retained at the time of the birth of the respondent, and continued down to the period of the marriage of the respondent's parents in Scotland. In considering these questions, it will be necessary to ascertain the nature and effect of a domicile of origin, whether it is like an after-acquired domicile, which, when it is relinquished, can be reacquired only in the same manner in which it was originally acquired, or whether, in the absence of any other domicile, the domicile of origin must not be had recourse to for the purpose of determining any question which may arise as to a party's personal rights and relations. Story, in his Conflict of Laws sect 48, says the moment a foreign domicile is abandoned, the native domicile is reacquired. Great stress was laid by the appellant in his reference to this passage upon the word reacquired, which is obviously an inaccurate expression. For, as was pointed out in the course of the argument, a domicile of origin is not an acquired domicile, but one which is attributed to every person by law. The meaning of story, therefore, clearly is that the abandonment of a subsequently acquired domicile ipso facto restores the domicile of origin. And this doctrine appears to be founded upon principle, if not upon direct authority. It is undoubted law that no one can be without a domicile. If, then, a person has left his native domicile and acquired a new one, which he afterwards abandons, what domicile must be resorted to determine and regulate his personal status and rights. Sir John Leach v. C. in Monroe v. Douglas held that in the case suppose the acquired domicile attaches to the person till the complete acquisition of a subsequent domicile, and he said there was no difference in principle between the original domicile and an acquired domicile. His Honor's words are, "A domicile cannot be lost by mere abandonment. It is not to be defeated animo merely, but animo et facto, and necessarily remains until a subsequent domicile be acquired, unless the party die in itinerary towards an intended domicile." There is an apparent inconsistency in this passage, for the Vice-Chancellor, having said that a domicile necessarily remains until a subsequent domicile be acquired animo et facto, added, unless the party die in itinerary towards an intended domicile. That is, at a time when the acquisition of the subsequent domicile is incomplete and rests in intention only. I cannot understand upon what ground it can be alleged that a person may not abandon an acquired domicile altogether, and carry out his intention fully by removing animo non revertendi, and why such abandonment should not be complete until another domicile is acquired in lieu of the one thus relinquished. Sir William Scott, in the case of the Indian chief, said, "The character that is gained by residence ceases by residence." It is an adventitious character which no longer adheres to a person from the moment he puts himself in motion bona fide to quit the country sign animo revertendi. And he mentions the case of a British-born subject who had been resident in Suriname and St. Eustatius, and had left those settlements with an intention of returning to this country, but had got no farther than Holland, the mother country of those settlements, when the war broke out, and it was determined by the Lords of Appeal that he was an itinerant, that he had put himself in motion, and was in pursuit of his native British character. Sir John Leach seems to me to be incorrect also in saying that in the case of the abandonment of an acquired domicile there is no difference in principle between the acquisition of an entirely new domicile and the revival of the domicile of origin. It is said by Story, in sect 47 of his Conflict of Laws, that if a man has acquired a new domicile different from that of his birth, and he removes from it with an intention to resume his native domicile, the latter is reacquired even while he is on his way in itinerary, for it reverts from the moment the other is given up. This certainly cannot be predicated of a person journeying towards a new domicile, which it is his intention to acquire. I do not think that the circumstances mentioned by Story in the above passage, viz., that the person has removed from his acquired domicile with an intention to resume his native domicile, and that he is in itinerary for the purpose, are at all necessary to restore the domicile of origin. The true doctrine appears to me to be expressed in the last words of the passage. It reverts from the moment the other is given up. This is a necessary conclusion, if it be true that an acquired domicile ceases entirely whenever it is intentionally abandoned, and that a man can never be without a domicile. The domicile of origin always remains, as it were, in reserve, to be resorted to in case no other domicile is found to exist. This appears to me to be the true principle upon this subject, and it will govern my opinion upon the present appeal. SS 195. ID. Lord Westbury's remarks. Lord Westbury said, the law of England, and of almost all civilized countries, ascribes to each individual at his birth two distinct legal states or conditions, one by virtue of which he becomes the subject of some particular country, binding him by the tick of natural allegiance, and which may be called his political status, another by virtue of which he has ascribed to him the character of a citizen of some particular country, and as such is possessed of certain municipal rights and subject to certain obligations, which latter character is the civil status or condition of the individual, and may be quite different from his political status. The political status may depend on different laws in different countries, whereas the civil status is governed universally by one single principle, namely that of domicile, which is the criterion established by law for the purpose of determining civil status. For it is on this basis that the personal rights of the party, that is to say, the law which determines his majority or minority, his marriage, succession, testacy or intestacy, must depend. International law depends on rules which, being in great measure derived from the Roman law, are common to the jurisprudence of all civilized nations. It is a settled principle that no man shall be without a domicile, and to secure this result the law attributes to every individual as soon as he is born the domicile of his father, if the child be legitimate, and the domicile of the mother, if illegitimate. This has been called the domicile of origin, and is involuntary. Other domiciles, including domicile by operation of law, as on marriage, are domiciles of choice. For as soon as an individual is sui juris, it is competent to him to elect and assume another domicile, the continuance of which depends upon his will and act. When another domicile is put on, the domicile of origin is, for that purpose, relinquished and remains in abeyance during the continuance of the domicile of choice. But as the domicile of origin is the creature of law, and independent of the will of the party, it would be inconsistent with the principles on which it is by law created and ascribed to suppose that it is capable of being by the act of the party entirely obliterated and extinguished. It revives and exists whenever there is no other domicile, and it does not require to be regained or reconstituted animo et facto, in the manner which is necessary for the acquisition of a domicile of choice. Domicile of choice is a conclusion or inference which the law derives from the fact of a man fixing voluntarily his sole or chief residence in a particular place, with an intention of continuing to reside there for an unlimited time. This is a description of the circumstances which create or constitute a domicile, and not a definition of the term. There must be a residence freely chosen, and not prescribed or dictated by any external necessity, such as the duties of office, the demands of creditors, or the relief from illness, and it must be residence fixed not for a limited period or particular purpose, but general and indefinite in its future contemplation. It is true that residence, originally temporary or intended for a limited period, may afterwards become general and unlimited, and in such a case, so soon as the change of purpose or animus maendi can be inferred, the fact of domicile is established. The domicile of origin may be extinguished by act of law, as, for example, by sentence of death or exile for life, which puts an end to the status civilis of the criminal, but it cannot be destroyed by the will and act of the party. Domicile of choice, as it is gained animo et facto, so it may be put an end to in the same manner. Expressions are found in some books, and in one or two cases, that the first or existing domicile remains until another is acquired. This is true if applied to the domicile of origin, but cannot be true if such general words were intended to convey the conclusion that a domicile of choice, though unequivocally relinquished and abandoned, clings, in despite of his will and acts, to the party until another domicile has animo et facto been acquired. The cases to which I have referred are, in my opinion, met and controlled by other decisions. according to the dicta in the books and cases referred to, if the Englishman whose case we have been supposing lived for 20 years after he had finally quitted Holland without acquiring a new domicile, and afterwards died intestate, his personal estate would be administered AC, according to the law of Holland, and not according to that of his native country. This is an irrational consequence of the supposed rule. But when a proposition supposed to be authorized by one or more decisions involves absurd results, there is great reason for believing that no such rule was intended to be laid down. In Mr. Justice Story's Conflict of Laws, it is stated that the moment the foreign domicile is abandoned, the native domicile or domicile of origin is reacquired, and such appears to be the just conclusion from several decided cases, as well as from the principles of the law of domicile. In adverting to Mr. Justice Story's work, I am obliged to dissent from a conclusion stated in the last edition of that useful book, and which is thus expressed: the result of the more recent English cases seems to be that for a change of national domicile there must be a definite and effectual change of nationality. In support of this proposition, the editor refers to some words which appear to have fallen from a noble and learned lord in addressing this house in the case of Merhouse v. Lord, when, in speaking of the acquisition of a French domicile, Lord Kingsdown says, "A man must intend to become a Frenchman instead of an Englishman." These words are likely to mislead if they were intended to signify that for a change of domicile there must be a change of nationality, that is, of natural allegiance. That would be to confound the political and civil states of an individual, and to destroy the difference between patriot and domicilian. The application of these general rules to the circumstances of the present case is very simple. I concur with my noble and learned friend that the father of Colonel Utney, the consul at Leghorn, and afterwards at Venice, and again at Leghorn, did not by his residence there in that capacity lose his Scotch domicile. Colonel Utney was, therefore, a Scotchman by birth. But I am certainly inclined to think that when Colonel Utney married and settled in life, and took a long lease of a house in Grosvenor Street, and made that a place of abode of himself, and his wife and children, becoming, in point of fact, subject to the municipal duties of a resident in that locality, and when he had remained there for a period, I think, of 32 years, there being no obstacle in point of fortune, occupation, or duty, to his going to reside in his native country, under these circumstances, I should come to the conclusion, if it were necessary to decide the point, that Colonel Utney deliberately chose and acquired an English domicile. But if he did so, he has certainly relinquished that English domicile in the most effectual way by selling or surrendering the lease of his house, selling his furniture, discharging his servants, and leaving London in a manner which removes all doubt of his ever intending to return there for the purpose of residence. If, therefore, he acquired an English domicile, he abandoned it absolutely and imo facto. Its acquisition being a thing of choice, it was equally put an end to by choice. He lost it the moment he set foot on the steamer to go to Boulogne, and at the same time his domicile of origin revived. The rest is plain. The marriage and the consequences of that marriage must be determined by the law of Scotland, the country of his domicile. SS 196, ID, Doctrine of Utney v. Utney not drawn from the civilians. From Lord Hatherley's criticism of the remark which fell from Lord Cottenham in Munro v. Munro, it is evident that the doctrine of Utney v. Utney was not influenced by the views held by some of the civilians with regard to the immutability of domicile of origin. So far as authority goes, it seems to have rested entirely upon the cases in the English prize courts, and aside from direct authority, it seems to have been tinctured very largely by the views then held in Great Britain with regard to perpetual allegiance. SS 197, ID, Domicile of origin in the early British cases. It is noteworthy that in the earliest cases in the House of Lords, Bruce v. Bruce, Almany v. Bingham, 2 and Bemp v. Johnstone, no special significance seems to have been attached to domicile of origin. Indeed, Lords Thurlow and Loughborough, who delivered the judgments in those cases, do not appear to have arrived at any very clear conception of domicile of origin, as it was then understood on the continent, and subsequently came to be understood in Great Britain. The celebrated third rule of Lord Alvanley in Somerville v. Somerville evidently was not extracted from those cases, but from the foreign authorities cited in the argument. It is the first distinct recognition which we have in English jurisprudence of any special adhesiveness of domicile of origin, and that of no artificial or technical kind, but one flowing naturally from the usual conduct, habits, and feelings of men, and entirely consistent with the complete obliteration of domicile of origin upon the acquisition of a new domicile. SS 198, ID, Udney v. Udney in the British prize cases. An examination of the English prize cases shows that the doctrine held in them goes even beyond that of Udney v. Udney. It is clear that in the latter case their lordships meant to go no further than to hold that domicile of origin reverts upon quitting communim non revertendi the country in which domicile of choice has been acquired. But the doctrine of Sir William Scott and the Indian chief requires only that the person should put himself in motion bona fide to quit the country sign animo non revertendi, whereupon the adventitious character gained by residence ceases, although he may be detained by matters of business or the like, and may not actually remove. In the case of the Snell Zailder, which Sir William Scott relied upon, and which was referred to by Lord Chelmsford in Udney v. Udney, Mr. Curtisos, a British-born subject, went to the Dutch settlement of Suriname in 1766, and from thence to the island of St. Eustatius, where he remained until 1776. From thence he went to Holland to settle his accounts, with an intention, as was said, of returning afterwards to England to take up his final residence there. He thus had passed from one part of the Dutch dominions to another, but had not quitted Dutch territory, and he did not return to England until 1781. While in Holland, however, war broke out, and his ship and goods were captured by the British and condemned in the Court of Admiralty as Dutch property. Upon his return to England he took an appeal, and his vessel and cargo were restored to him, the Lords of Appeal holding that he was an itinerant, that he had put himself in motion, and was in pursuit of his original British character. The Ocean was the case of a vessel owned by a British-born subject who had settled in Holland in trade, and who, upon the approach of hostilities, arranged to return to England, and was only prevented from so doing by the violent detention of all British subjects who happened to be in the Dutch territories at the breaking out of the war. Under these circumstances, Sir William Scott held him entitled to restitution. In the President, the same judge uses language to the effect that all that is necessary is to show some solid fact showing that the party is in the act of withdrawing. Such cases, if followed as authorities upon the general subject of domicile, are likely to introduce doctrine fraught with no little confusion and uncertainty in questions of status, personal succession, and the like. For example, if Mr. Curtisos had died while in Holland, would his personal estate have been distributable according to the laws of England? Or would the majority or minority of his children, if he had any, have been determined by the laws of the latter country? It can hardly be thought so. This line of discussion need not be pursued any further. What has been said has been for the purpose of showing, first, that, so far as Udney v. Udney rests upon authority at all, it rests upon that of the British prize cases, and, second, that those cases go too far to be followed in ordinary cases of domicile. Moreover, they are so mixed up with considerations peculiar to themselves, and which do not apply to domicile in general, as to render them wholly unsafe as guides in any cases except those involving national character in time of war. Among others, Dr. Lushington has, in Hodson v. the Beauchesney, warned us against their use. He says, this species of domicile is, it is true, in one sense, domicile jure gentium, but in many particulars it is governed by different considerations, and decisions belonging to it must be applied with great caution to the questions of domicile independent of war. SS 199, ID, Objections on Principle to Udney v. Udney. On principle, however, there are many objections which can be urged against the doctrine of Udney v. Udney, the main one, besides what has been already said in the chapter on domicile of origin, being its extreme artificiality and the fact that it entirely loses sight of the essentially voluntary character of domicile. It may be said, and with great force, that the adherence of a domicile of choice to a person after it has been abandoned would also be involuntary and artificial. The necessity of imputing to a person who is homeless in fact a domicile somewhere, compels a resort to some artificial rule. It is true, but it would seem most consonant with the general principles of the subject to restrict as far as possible the application of purely technical fictions. And of all the fictions relating to domicile, that of domicile of origin is the most highly technical. For a person may have a domicile of origin in a country without having ever had the least semblance of a home there. With respect to the remark of Lord Westbury, that if a natural-born Englishman domicile himself in Holland, and afterwards break up his establishment there and remove, intending never to return, it is absurd to suppose that his Dutch domicile clings to him until he has set up his tabernacle elsewhere. It may be said that such a supposition is certainly no more absurd than to suppose that his domicile of origin, which is merely imputed to him by law, and into the constitution of which no act or intention of his own has entered, should cling and adhere to him in spite of every effort to rid himself of it, should continue to follow him around the world, and notwithstanding his fixed intention never to reassume it, should persistently control his capacities during his life and the distribution of his estate after his death. We can suppose the case of one removed in infancy from his domicile of origin by his parents to another country, where they become naturalized citizens, and where he grows to manhood, and where he himself on attaining his majority assumes citizenship. It does seem unreasonable to hold that upon quitting this acquired domicile with an intention of seeking an abode elsewhere, he should be relegated for his status civilis to a country to which he bears no allegiance, of which he may not have the slightest recollection, and with which he may be connected by no ties of kindred or association. In short, a country with which his only bond of connection is that his parents happened to be domiciled there at the time of his birth. Or suppose a somewhat stronger case, the parents of it are native-born Americans, and intending to set up a permanent abode in Russia they journey thither, while in England an itinerant A is born. Clearly his domicile of origin is American. His parents permanently establish themselves in Russia and die there. A grows to manhood, marries, raises a family, and accumulates property there. In middle life he quits that country, intending to settle in France, but dies an itinerant in Germany. If the doctrine of Udny v. Udny is of universal application, the distribution of a personal estate would be determined by the laws of some American state upon whose soil he may never have set foot, and with whose law he may be entirely unacquainted. This is indeed an extreme case, but not an improbable one. In Udny v. Udny, Colonel Udny was not born at his domicile of origin, and for anything which is to be found in the books to the contrary, if he had grown up in Spain and had never seen Scotland, the doctrine of their lordships would have imputed to him a domicile in Scotland immediately upon quitting England. SS 200, Westlake on Reverter. Evidently impressed with the harshness of such results, Westlake has sought to provide against them by assuming as the domicile of origin that domicile which the person had when he first acquired the power of changing his domicile for himself, and by holding that reverter takes place only when the person has set out to resume his domicile of origin, or has abandoned his domicile of choice without any sufficient intention being directed towards any other country. The first position, however, is not only not supported by the authorities, but is directly contradicted by them, the plain result of the cases being that the domicile of origin of a person is that which attaches to him at birth, and no other. The second position is equally untenable in view of Udny v. Udny. For their lordships there holds substantially that domicile of choice is an adventitious domicile which ceases upon abandonment, that it may be abandoned simpliciter, and that thereupon the original domicile simpliciter reverts. Indeed, no other construction can be put upon the language used in that case than that upon the abandonment of one acquired domicile in order to establish another. The domicile of origin springs out of abeyance to fill up the gap between the two. Westlake assumes that in the event of death in itinerant the last domicile is that towards which the person is journeying. But suppose he does not die. Suppose, for example, a child is born of whom the person in itinerant is the father. By what law would the capacity for legitimation of such child be determined? By that of the country towards which the father is journeying? Clearly not. Then we are driven for an answer either to the law of the domicile of origin, or that of the lately abandoned. Domicile. Suppose a wife die while her husband is thus in itinerant. Can it be that her testamentary capacity or the distribution of her personal property would be governed by the law either of his intended domicile or of his domicile of origin? Suppose he be a Russian or an Italian who has become domiciled in New York and has married a New York woman who has died while he is an itinerant, for example, to Canada, to establish his domicile there, or suppose that for some purpose his personal capacity is called in question. Is it not more reasonable to determine it by the laws of a country which he has once voluntarily chosen as his home, even though he has abandoned it, than by the laws of a country with which he may be connected only by ties which are wholly artificial, and rest in pure fiction? SS 201. American Doctrine of Reverter. In this country, the doctrine of reverter of domicile has been received substantially as stated by Story, namely, that domicile of origin reattaches upon abandonment of domicile of choice and setting out for the place of domicile of origin with intention to remain there. Lowell, J., thus states it in Walker's case. The general rule is that a domicile once acquired remains until a removal has been effected to some other place with intent to remain there. But there is an important exception in favor of the native domicile, by which a mere removal from the new and acquired home, with intent to return to that of origin, revives the latter eo instanti. It is true that there have been some dicta in conflict with this view, but most of the cases have followed Story either in words or in substance. Moreover, it is laid down in a large number of cases, and may be taken to be the consensus of American judicial opinion, that domicile once acquired continues until another is acquired facto et nemo, an exception being made in favor of reverter of domicile of origin, as above stated. SS 202. Doctrine of Udny v. Udny not held on the continent. The doctrine of reverter as announced in Udny v. Udny is not held at the present time upon the continent. Indeed, it may be said to be as distinctively British as it is the outgrowth of the doctrine of perpetual allegiance, which Great Britain, last of all the European nations, clung to. But as it has been settled by a solemn judgment of the House of Lords, it must remain the British doctrine until overturned by Act of Parliament. SS 203. Reverter will not be presumed burden of proof upon him alleging reverter, but the rule that the person who asserts a change of domicile must prove it applies as well when the question is one of reverter as when it is one of the acquisition of a domicile of choice. Reverter, therefore, will not be presumed, and the onus probandi rests upon him alleging it. Mere intention to return to the domicile of origin at a future time is not sufficient, nor is mere return without abandonment of the acquired domicile. SS 204. The requisite factum for reverter. The necessary factum to accomplish reverter is quitting the country of the acquired domicile, that is, passing beyond its territorial limits. This is illustrated by the decision of Sir Cresswell in Goods of Raffinal. In that case, an English woman by birth married a Frenchman and lived with him at Dunkirk until his death. Several years after that event, she left Dunkirk and went to Calais with her children and baggage, intending to go to England, there to reside permanently. She embarked upon a steamer bound for England, but before it sailed she was taken ill, and was obliged to reland at Calais, where she remained for some months in the hope of recovering sufficiently to bear the voyage to England. She continued, however, too ill to risk the voyage, and returned to Dunkirk, where she died several months afterwards. Upon these facts her domicile was held to be French, Sir Cresswell remarking that he could not think there was a sufficient abandonment so long as the deceased remained within the territory of France, her acquired domicile. In the Alabama case of State v. Graham, where the petitioner for discharge from military service appeared to have been prevented from leaving Alabama, where he had acquired a domicile, and returning to his native country, by the breaking out of the war and want of funds, it was held that his acquired domicile remained. These cases are in striking contrast with the English prize cases above referred to, but the doctrine contained in them appears to be entirely sound when applied to domicile, properly so called. SS 205. The requisite animus non revertendi. Abandonment must clearly appear. A mere contingent intention not to return to the acquired domicile is not sufficient. Abandonment must be final and complete, although a distant possibility of return to the place of the acquired domicile will not prevent reverting. SS 206. The transit to domicile of origin need not be direct. Even upon the American theory of reverter, it is of no consequence that the return home is not immediate, or by the shortest road, if the fact of final abandonment and the intention to return to the old concur. the domicile is changed from the time that the new is actually left. Thus, in Walker's case, in which the facts were that W, who was born in Boston and had become domiciled in California, left California intending not to return but to go to Boston and remain there. Lowell, J, held that his domicile of origin had reverted, although he journeyed from San Francisco to Boston by way of France, remaining in that country for 11 months. It is true that Judge Lowell relied upon Mr. Curtiso's case as an authority for this position, but it doubtless can be sustained on principle, and it is to be noted that while in the former case Mr. Curtiso's remained within the Dutch dominions, W had actually passed beyond the territorial limits of the state of California. SS 207, quasi-national domicile, the subject of reverter, otherwise as to municipal domicile. It was said in the Connecticut case of Bank v. Valcom that the doctrine of reverter does not apply to quasi-national domicile, but this position was not necessary to the decision of the case and is inadmissible in view of the abundant authority to the contrary. There is no reason to suppose that the principle of reverter is applicable to municipal domicile. SS 208, acquired domicile not the subject of reverter. The principle of reverter, at least in its technical sense, is not applicable to acquired domicile. It is easy to understand that fewer circumstances may be required to show the reacquisition of a former domicile of choice than the acquisition of an entirely new one. But it cannot thence be concluded that anything short of the complete factum of transfer of bodily presence to a former domicile of choice will suffice to reacquire it. Since Utne v. Utne, there can be no doubt of the position of the British courts upon this point. But in this country there have been some expressions used which might seem to give some countenance to such doctrine. In the Venus, a prize case, Washington, J, said, having once acquired a national character by residence in a foreign country, he ought to be bound by all the consequences of it until he has thrown it off, either by an actual return to his native country, or to that where he was naturalized, or by commencing his removal, bona fide and without an intention of returning. This language is open to several different constructions, and by no means definitely asserts reverter of acquired domicile, at least without actual return. But it is evident that the learned judge was somewhat confusing national character and allegiance, and such may have been his thought. Moreover, it is possible to entertain such a view of reverter of national character without putting it distinctly and entirely upon the ground of domicile. It was, however, apparently to meet this doctrine, that Story in his work on the conflict of laws laid down the following: a national character acquired in a foreign country by residence changes when the party has left the country animo non revertendi and is on his return to the country where he had his antecedent domicile, and especially if he be an itinerant to his native country with that intent, his native domicile revives while he is yet in transitu, for the native domicile easily reverts. This language has been repeated in the Texas case of Mills v. Alexander, but so far as the writer is aware, the doctrine of reverter of acquired domicile has never been distinctly held in any case.